I mean, one thing that immediately springs to mind is discount rate.
It's trying to get the right figure so that if you invest it properly, you get that money each year.
As I say, overnight, the claim went from being worth one number to being worth a different number, and in fact, a lower number.
No, you have to be prepared to fight, but not at all costs.
But of course, those costs have been incurred and somebody's got to pay them. And I think the risk with fixed costs is that it's the poor claimant who ends up paying more.
Nobody benefits when the lawyers are being spiky with each other.
Hello, and welcome to today's episode of Medical Negligence Matters. And for this final episode of this series, we're going to be looking at legal reforms, both recent and proposed, which have a likely impact for claimants in clinical negligence cases. And we're covering this really with a view to informing our listeners and our viewers, not necessarily aiming it at specialist lawyers. But with me today to talk about the subject are my colleagues Corrina Mottram and Tami Frankel. Hello both.
Hi.
So, key areas of legal reform. I think perhaps taking a step back, it's worth sort of pointing out to people that the clinical negligence work, of course, is part of the civil justice system as opposed to the criminal system. And that has different standards, doesn't it? Or different standards of proof. So it might be helpful, I guess, to explain to our listeners how medical negligence sort of fits into the legal system as it stands.
Yeah, well, of course, medical negligence is part of the civil system, which means we have a different burden of proof. You still have two sides, but the two sides are two individual parties, even if one of the parties happens to be an organisation of some sort. And you have ultimately a judge who is going to determine which side wins. But of course, as a claimant, you're bringing the case, you do have a burden of proof. You have to prove on the balance of probability, so more likely than not, which some people do call 51%, but isn't necessarily 51%. But what you're saying is accurate. It actually means that for the defendant, they don't have to do anything until you reach that burden and then they rebut it. So in many ways, you might think a defendant has an easier job of it than a claimant.
Yes. And the civil system, of course, is governed by a set of very detailed rules, which are subject to constant review and change. I mean, the Civil Procedure Rules Committee is constantly looking at those rules that govern the civil system and looking at areas that can be improved or changed, with a view, hopefully, to improving the process for both claimants and defendants alike. And thinking about some of the developments that have happened over the last year or so, I mean, one thing that immediately springs to mind is discount rate.
Yes, yeah.
Perhaps could we explain a little bit about what the significance of that for individual claimants?
Well, I think the way the discount rate impacts claims is in relation to recovery for future losses. So if you've got, say, loss of earnings or claims for care and support that you need going into the future for a number of years, the discount rate affects how that is calculated. And effectively, it's like it adjusts the number of years' worth of the loss that you can claim.
So it affects the maths, really, doesn't it?
It absolutely affects the maths, and it affects the amount you recover. And over the last several years, quite a long time, there have been several quite significant changes in that discount rate. It's gone from a position that was very unfavourable to claimants to one that was really very favourable to claimants. And as of January 2025, it's swung back a bit the other way. It's nowhere near as unfavourable as it used to be. But it's significantly more restrictive than it has been over the last couple of years. And
I suppose it's important for people to understand that really the reason for that is that the discount rate reflects, in a sense, the performance of the economy as a whole. And fluctuations in that economy affects how actuaries assess damages should be calculated. It's quite a complex process. But It is, as I understand it, in its simplest form, it's trying to reflect what your kind of investment return would be. If you put a lump sum in the bank, at what level do you need to invest to recover the kind of money that you would have been losing year on year because of the loss of earnings or the care that you need to pay for and what have you? It's trying to get the right figure so that if you invest it properly, you get that money each year. And that constantly changes, as you say, with the performance of the economy.
Yeah, it's a balancing act between the claimant and the defendant in a way, because you don't want the claimant undercompensated, but you don't want them overcompensated either. So trying to find a figure which will be the right amount for their loss for 10 years, meaning that for every year for the next 10 years they get the right amount if they invest it prudently, is really difficult. So it's
and I suppose this change is one of those ones that has affected claimants whose cases are already ongoing, isn't it? I mean, most reforms that happen are not retrospective, so that a change happens and it only applies to future cases. The change in the discount rate is one of those things that actually affected every claimant who had a claim for future losses, because, as you say, overnight the claim went from being worth one number to being worth a different number, and in fact a lower number.
It was affecting claims, in fact, before the rate was known, because it was known that the rate was being reviewed. And the minute you know the rate is being reviewed, you think, is that review going to be favourable or not? And it meant, for instance, that we had quite a number of settlement meetings in large cases put on hold by defendants, because I think everyone knew it was going to become less favourable to claimants. We just didn't know what the exact figure was going to be. And it can be a huge amount of money in a large claim. So you can't blame the defendants, but it did cause difficulties for a good year,
Yes, I mean, it's one of those things that has added delay, inevitably, I think, in some cases, hasn't it? Because it has postponed settlement in a lot of cases.
In a lot of cases,
because of those changes. And I think one of the other very significant things that has happened in the last couple of years, which has been talked about for a long time, is the introduction of fixed costs.
Yeah.
And I mean, costs is an issue that is always being spoken about in the media and within the profession, because of course it's understood that litigation is an expensive process.
Yeah.
And I think that as a society, I mean, I think there is some concern about, particularly in medical negligence, the cost of medical negligence to the NHS as a whole. And a lot of attention has been spent on trying to look at ways of limiting that cost. But of course, the difficult balance is do you reduce the cost without actually impacting the ability of a claimant to bring the claim and that access to justice?
Yeah, no.
And fixed costs has been introduced to a limited extent, hasn't it, already?
Yeah, no, in claims worth £25,000 to £100,000, the scheme has now been enacted, and it means that if you take on a case which when you first look at it, you think is in that ballpark. And of course, that's the very first difficulty, is valuing a case the minute you get it through the door. You have an idea, but you have no evidence. And you don't really know a person's prognosis. So you really don't know the value, but you have to do your best to value it at that stage. And if it's in that ballpark figure of £25,000 to £100,000, you know there are limits to how much, even if you're successful, so you've proven that the defendant did something wrong, your client suffered as a result, that your client may not recover all of their costs against that defendant, even though those costs were reasonably and necessarily incurred in order to get them to that position. It's really difficult.
I think the problem is, and it's not understood by a lot of people, is that the complexity of the case has got nothing to do with the value of the claim.
Completely
and you can
unrelated.
have something that's actually got a value in terms of compensation that's really very modest, but is incredibly difficult to prove, and you might need input from any number of experts, which is expensive.
That's particularly so in medical negligence, isn't it? Because of our reliance on independent expert evidence and that the burden of really most of the evidence and most of the knowledge about the facts of a case being in the hands of the defendant at the outset. The claimant quite often knows very little about it. And I think the difficulty with fixed costs from a claimant point of view is as you said, Tami, having to take on a case without really knowing whether or not you're going to be within that regime or whether you're not. And that uncertainty is very difficult. And thinking about how those reforms actually impact on a claimant. I mean, we've spoken about the discount rate and how that alters overnight the numbers in a case. Fixed costs, I mean, also potentially has serious implications for claimants, doesn't it? Because the reality is, in this country, the rule is that on the whole, the loser pays. So the winner in a civil claim has the right to have their costs paid by the opponent. But what fixed costs does is it puts a limit on the amount of those costs that can be recovered. But of course, those costs have been incurred and somebody's got to pay them. And I think the risk with fixed costs is that it's the poor claimant who ends up paying more
or risks not investigating their case properly. That's the choice people are left with. If I'm worried I won't recover all of my costs, do I get this extra report, which may or may not prove some additional angle to it? Yeah, it's a really awful dilemma to put people
Yes,
through.
this is the difficulty for the lawyers in advising claimants, isn't it? Because you don't want to cut corners, because cutting corners can just result in a really terribly bad outcome and sort of destroys the whole object of pursuing the case in the first place. And so I think that lawyers have got to be very astute about this, keeping up to date with the changes and making sure that clients are properly advised about the implications of the potential fixed costs. And I suppose looking forward, I mean, there's constantly changes on the agenda. I mean, there's been talk for some time about extending fixed costs even further, and perhaps changing the process. And I think most claimants would agree that there can't really be any change to the costs without changing the process.
Yeah.
No, the two have to go hand in hand.
And the process is complex.
And I think it comes back to the whole issue that the complexity of the claim doesn't necessarily isn't necessarily reflected in the value of the claim. And if you limit costs for more modest claims, you risk seriously undercompensating people because they can't investigate, as Tami said, properly.
It also doesn't do anything to encourage defendants to settle early.
No.
Because they know you have a barrier, a recoverable costs barrier that you're trying hard not to breach. And so if they can make you reach that barrier earlier, it's better for them. It doesn't seem fair in lots of ways.
That's the difficulty, isn't it? Is the impact on the individual, when really what needs to be, or what might more profitably be looked at, is reducing the number of claims for a start, but then also reducing the number of claims which are fought beyond the point at which they ought to be. I mean, earlier admissions of liability would, and I think, to be fair, already are, in some cases, resulting in considerable savings in costs without the need for any whole-scale reform.
Yeah, absolutely. Well, you can, once you have an admission on some areas, you can move forward together to resolve it, to value it. You always need to do work to value your claim, but you can move forward together. You can move forward more quickly and with less cost.
And I think most lawyers at heart, even the most toughened, hardened litigators, would accept that collaboration and cooperation is the right way forward to get the best result for the client.
Nobody benefits when the lawyers are being spiky with each other just on principle. That doesn't help anybody. You know, the claimant doesn't get a better service just because your lawyer's being performatively aggressive.
No, you have to be prepared to fight, but not at all costs.
No, absolutely.
It's your last resort rather than your first port of call.
I think that's right, isn't it? Because although the clients may feel that they want their day in court, those of us who've been there know that it's seldom a pleasant experience for the individual client, and that if there is a way of achieving the right outcome in a less confrontational way, that's the way to fact to everybody's benefit.
Yeah.
Thinking broadly sort of beyond costs, I mean, I think over the years there's been a lot of talk about changing the scheme entirely for personal injury and in particular clinical negligence claims, and raising this idea of no fault compensation. I mean, that's something that within politics has been very much a hot topic. And superficially, it seems like an attractive idea.
It does, but I think there are some examples of no-fault schemes around the world, but I think they operate in a really different way to our compensation system at present.
Yes, I mean, what we mean by no fault really is, I mean, I suppose we should be clear about this. At the moment in clinical negligence, we have to prove, first of all, that somebody was at fault, that there was a breach of duty, a breach of the standard of care somewhere, and then secondly, that it caused the injury. All that a no-fault scheme does really is to remove the first step, isn't it? And isn't that the difficulty?
Yeah, and you would have a wider number of claimants. You would have a scheme that was done. I mean, in a way, we do have something similar in the CICA, the Criminal Injuries Compensation Scheme, in that we do have a scheme that people can apply to. And if you see the way that is administered and how...
It's very limited funds available for people.
It's a lot less. It's very much more limited. And claims don't really take any they're not settled any more quickly. No. They're really not.
No, I mean, I think that burden of proving the causation, I mean, I think even in a no-fault scheme, you would still have to prove that the injury that you have suffered is not part of the underlying disease process, but is part of, the result of something that occurred within the course of your treatment. And Tami, so you're right, you've also touched on this point, which I think people don't really consider, is that removing that sort of filter of having to prove fault does rather open the gates to a very significantly increased number of cases, potentially. Cases which, frankly, at the moment, most specialist lawyers filter out of the system. Yeah. And I think that the NHS would find that there were very many more people knocking on their door seeking compensation within a no-fault scheme.
Yeah. With no legal help, because I think the idea behind no-fault schemes is that you can do it without lawyers. You could, sort of the injured person themselves can fill in a form kind of thing, like you do with CICA, and make the claim. And that isn't fair apart from anything else, but it doesn't lead to savings in time at all.
And it certainly doesn't lead to, justice and proper recompense for the person who's been injured.
I mean, that's the point, isn't it? Is that a greater number of claims inevitably results in a finite pot of money being spread amongst a greater number of people. And the idea of getting adequate compensation is sort of goes out the window. Yeah. And you're right, Corrina, I think you touched on this idea that there are already schemes, such as the one in Sweden, which I think is acknowledged to work pretty well. But of course, what people don't take into account, I suppose, is that the tax burden in Sweden and the funding of healthcare and the social care system is very, very different to what we have here in this country. And I think the sort of tax rates that are applied to both employers and taxpayers in Sweden are things that are levels that would make your eyes water, or that the average UK taxpayer would have their eyes water.
It would be a whole kind of root and branch reform of so many sectors of society. It's not just a kind of plucking out of a system that works somewhere else and slotting it into us.
Yeah, I think the system certainly there is funded in a very different way, which means that social care is much more broadly available. And it's a smaller population, of course, and all these things are significant. So I think it's very difficult to try and take an illustration of something that happens in another country and sort of try and apply it here, because it's in a very different economic and social,
cultural.
So no easy answers on that. But it is an idea that I think will probably hang around for a while.
I'm sure.
But I'm not sure that anyone's really sat down and worked out the maths and the implications. I think there are some academics who are starting to look at perhaps the social cost and sort of weighing up whether or not it is something that's realistic. But I think there's a lot of work that needs to be done on that before it could be considered as a prospect in the UK. The other thing I was thinking about, real life sort of examples of how change and legal reform can affect claimants. I mean, the recent Supreme Court judgment in relation to secondary victims, I think, is a case in point, isn't it? That sometimes, and there's no getting away from this, that sometimes changes that happen during the course of a case have an enormous impact.
Yeah, I mean, in the case that you're referring to, a decision was handed down by the Supreme Court one day, and that meant the next day we had to go and advise a whole swathe of our clients that claims we had been investigating were no longer viable because the Supreme Court decision had changed the way the law was understood to operate in that area.
Yeah, so that's a prime example, isn't it, of a change which is, as I said earlier, most changes are not retrospective, but this most certainly was, and so has an overnight impact. And I think it's really important, I guess, that people who are advising clinical negligence claimants do very much stay on the pulse of what's happening within the legal system. And certainly within our own firm, we have a weekly meet, don't we, really, to exchange this sort of information to make sure that everybody is up to date with what's going on, changes in the law, changes in procedure, changes in performance of
just sort of practical tips that we've each picked up from discussions we've had with experts or defendants or whoever.
Court hearings we've had and seen how things are actually going on the ground, how things really are. At court.
Chats with barristers about things they've experienced and how we can all help to kind of ensure that we all know as much as possible about what's going on in the real world, as it were.
Yeah, I mean, I'm conscious that we talk about a lot of changes as if they're all negative, and of course they're not, are they? I mean, there are some changes that are very positive, and I think a lot of changes that were brought in by the civil procedure rules, changes, efficiencies in the process has helped an awful lot. And there's also changes like the digital court systems. Sometimes a bit difficult for solicitors to get grips with. Initially, we're used to dealing with things on paper, and suddenly filing things online and this sort of thing can seem a bit daunting. But in fact, it has improved efficiency, I think.
Oh, you no longer have to send someone. If we want to issue something in the High Court in London, we no longer have to send someone down there on the train with the paper copies to issue it. We can do it, from our desk in 10 minutes. There are millions of efficiencies. Yeah.
And the kind of the accessibility and availability, certainly of High Court masters, who are sort of procedural judges who will deal with claims prior to trial, the accessibility of them via email is a huge benefit.
Yeah. Again, no longer having to go down in person to London, to the practice master to try and get to ask for whatever you need to ask for.
And so I suppose the takeaway for our listeners and our viewers is getting the right advice, isn't it, really?
Yeah.
Getting in touch with specialists who are most likely to keep their fingers on the pulse of what's going on in the clinical negligence world and can give you the best up-to-date advice.
And represent you the best because they know what's going on the ground, how things are evolving, and they can do the best for you,
Yeah, absolutely.
Thank you both for your input on that.
Thank you.